that it was 2 years after the president was elected before a nominee was even sent up here. So we can't confirm anybody that isn't sent up here. And then when Mr. Traver was set up here, the committee asked for additional information, which was never provided. Therefore, he never had a hearing. And of course, if the committee asks for additional hearing or additional information, and that information isn't given, and you can't have a hearing without it, that obviously is either the nominee or the White House's fault. Then Mr. Traver's nomination was withdrawn at the end of the last Congress, and Mr. Jones was nominated January 24th, and we started talking about the hearing in April. Then there's one other point that I would make, and that's in regard to what you said, and it isn't inaccurate what you said, but I want to point out that when this goes to OSC and it's in mediation, there's a big difference between being resolved and the president or the chairman in his letter to me saying it is resolved, because OSC, as I said in my statement, has made very clear that it's not resolved. Thank you, Mr. Dellery, for speaking about false claims, because I ask every Attorney General nominee, wherever they are in the department, about it, because I'm the author of that legislation, and I'm very glad to know that you're going to use it vigorously. Mr. Jones, you would not expect me to not be concerned about whistleblowers. I'm sure you know my reputation in that area, and not every whistleblower would necessarily be right, but every whistleblower is entitled to a hearing, either when they're personally affected and retaliated against, or in the case of somebody bringing information forward. They ought to have that information considered. And I've come to the conclusion a long time ago that whistleblowers are about as respected in their organization as skunks are at a picnic. So I think they need a lot of consideration, because they give us a lot of valuable information. On March the 6th, 2013, an employee of yours filed a complaint with special counsel alleging you personally undertook, quote, a prohibited personnel action, unquote, against him in retaliation for his raising concerns about gross mismanagement within the U.S. Attorney's Office. This employee has 30 years of as a federal employee, 24 of those years in the U.S. Attorney's Office in Minnesota. The employee alleges that after bringing serious concerns about mismanagement in the office to your attention, he was suspended for 5 days without pay and involuntarily transferred to a new section in the office. The complaint also raises allegations about the appointment of an attorney to a supervisory position despite concerns about her performance by federal and state law enforcement and judges on the federal bench. The special counsel wrote to us yesterday stating that the complaint was referred for investigation April of this year, and that the investigation remains open with possibility of mediation because of the majority scheduled your hearing, despite the fact that this investigation is pending. That's why I bring this matter up. You were quoted in the Star Tribune as saying, "I'm looking forward to meeting with the committee and answering all their questions." Based on that, I'm going to assume that you will answer the questions I ask you today. Mr. Oswald, first question. Mr. Oswald, former Special Agent Charge, FBI, Minneapolis, wrote a detailed letter this January alleging you mismanaged the office and had an, quote, atrocious professional reputation within the federal law enforcement community, end of quote. A 4-year veteran of assistant U.S. attorney filed a complaint with the Office of Special Counsel against you, which corroborates the account. Have you been interviewed by the Office of Special Counsel, and if so, when?
Senator, to answer your last question first, I am aware that the OSC has requested information from our office in the District of Minnesota. Because those complaints are confidential as a matter of law, I have not seen the substance of the complaints, nor can I comment on they are. I've learned more from your statement today than I knew before I came here this morning about the nature and substance of the complaint. I can assure you that I have always taken very seriously the duty my office has to follow all the laws and regulations, not engage in prohibited personnel practice, and to be very sensitive to the issues surrounding those that you have so vigorously advocated for over the years with respect to whistleblower protection.
So you have not been interviewed then by special counsel?
I have not, Senator.
Other than the FBI special agent in charge and the assistant U.S. attorney who filed the complaint with the Office of Special Counsel, are you aware of any other individuals in your office who have raised similar concerns, and if so, who?
I am not aware of any other complaints, Your Honor, Senator. This is like a courtroom, so I'm.
Well, I
feel like a defendant.
And as a farmer, I feel honored. Have you taken any adverse personnel actions against anyone who complained about how you were managing the office?
You know, Senator, that's thank you for the question. I have had the opportunity to be in a management position both in the public and private sector. I have always tried to approach that position of responsibility with respect for those that I work for, in a collaborative nature, but always with expectations. And I have.
So I think the answer to my question is you don't feel you have taken any adverse action against anyone who complained about how you were managing the office. Are you aware of the anonymous complaint filed July the 20th, 2012, signed by, quote, employees of the U.S. Attorney's Office for the District of Minnesota, end of quote? Those employees wrote, well, are you aware? Well, no, let me go on. Those employees wrote, quote, since he became U.S. Attorney here in Minnesota, he has instituted a climate of fear, has pushed employees out of the office, dismissed employees wrongly, violated the hiring practice of EEOC, and put in place an Orwellian style of management that continues to polarize the office, end of quote. Did you at any time learn who these individuals were? Did you take any adverse personnel action against them?
Senator, I recently saw a copy of that anonymous letter. Again, I have not taken adverse actions against anyone that I've worked with. I was quite surprised by the nature of the allegations, whether it's at ATF or at the U.S. Attorney's Office. In both situations, I came into a less than perfect environment, and I, quite frankly, been an agent of change, and change is hard sometimes for individuals to deal with, and I've always had a focus on doing the right thing for the right reasons, and sometimes folks are not happy about the direction overall. But
now, I'm including in that statement about adverse personnel action an unwanted retaliatory transfer. Does that change your answer?
Again, Senator, I'm not familiar with the OSC complaint, and I'm at somewhat of a disadvantage with the facts. I can say that Privacy Act considerations do fit into the picture. I have a certain awareness about disciplinary processes, but again, it has never been my practice to engage in retaliatory employment practices.
Will you answer the complaints about the assistant U.S. attorney when because that's why you're here today? How are we supposed to ask about these allegations if we can't ask you?
Well, quite frankly, Senator, I'm at a disadvantage with the facts. There is a process in place. I've not seen the OSC complaint. I do know that our office, working with the Executive Office of U.S. Attorneys, is in a process of responding to the issues that you've talked about this morning, but I have not had the opportunity to either be interviewed or have any greater knowledge about what the OSC complaint is.
Well, I'm kind of uncomfortable asking these questions because we shouldn't have been moving forward with this hearing, but the chairman said this was the opportunity for us to have this interview with you and to get these questions answered. And of course, you agreed to answer all the questions, so I would ask that you answer, but if you don't answer, that's the way it has to be.
Mr. Jones, thank you for being here. You are a currently sitting United States Attorney. You previously served as chairman of the Attorney General's Advisory Committee. You're the acting director of ATF. You are perhaps uniquely situated to discuss the Obama administration's priorities and record concerning gun prosecution. So I'd like to ask you a question. Is it a priority for the Obama Justice Department to prosecute felons and fugitives who attempt to illegally purchase firearms?
Senator, thank you for that question. And one of the priorities of the Department of Justice has always been, during my second tenure as U.S. Attorney, protecting the American public from violent crime, including violent firearms crimes.
Is that a yes?
That's a yes.
Would you describe it as a high priority?
It is one of the major priorities.
So a major priority.
Yes.
I guess then I would ask you to reconcile that comment that it's a high priority with the data. And in particular, in 2010, out of 48,321 felons and fugitives who attempted to illegally purchase firearms, the Department of Justice prosecuted only 44 of them. 44 out of over 48,000. And at least for me, I have difficulty reconciling those hard facts with the assertion you have made that it is a high priority of the Obama Justice Department to prosecute felons and fugitives who try to illegally purchase firearms.
During fiscal year 2012, Senator, the Department of Justice did approximately 85,000 federal criminal cases involving defendants, and 1 out of 7 involved firearms offenses. The NICS check does generate hits of people who are potentially prohibited, and you are correct in that the number of folks who are prosecuted federally for what has been coined lying and trying is a small number. But the number does not tell the story about what the department has done with armed career criminals.
With respect, sir, my question wasn't about armed career criminals. My question was whether it was a priority to prosecute felons and fugitives who try to illegally buy firearms. Now, this data focuses exactly on that. That's why I wanted... You could have said, no, it's not a priority. And I would suggest the data demonstrate it is not a priority of the Obama Justice Department to prosecute felons and fugitives. In my view, that's completely unacceptable. Do you disagree? Do you think prosecuting just 44 out of over 48,000 felons and fugitives who tried to illegally buy guns, do you think that's an acceptable allocation of prosecutorial resources?
Prosecutorial resources are thin, and there are a number of issues that U.S. attorneys across the country deal with, ranging from national security, financial frauds, and we have tough decisions to make. The reality is, as a first-line prosecutor and someone who exercises their discretion on a regular basis, if given the choice between doing a lying and trying case, which we have not done in Minnesota, and doing an...
So your office has
we
done
have
zero.
not done a lying and trying case.
Your office has prosecuted 0 felons and fugitives who tried to illegally purchase
We
firearms?
have not tried we have not prosecuted
Is that a
lying
yes?
and trying case. We have done over 150 felon in possession, armed career criminal cases. We have done straw purchaser cases. On the spectrum of prosecutions that U.S. attorneys can do, lying and trying cases, both because of the dedication of resources and the potential deterrent impact and the sentence that's going to be involved, are not commonly done, which is underlying that 44 figure that you cited earlier, Senator.
Mr. Jones, I have to admit I find it remarkable that you testified to this committee that it is a, quote, major priority of the Department of Justice to prosecute felons and fugitives who attempt to illegally purchase firearms, and that then you respond to this committee that it is an acceptable allocation of prosecutorial resources to prosecute just 44 out of over 48,000. And even more astonishingly, you inform this committee that you have prosecuted 0. My question to you is, are there other things you would describe as major priorities with the Department of Justice that at the same time you have chosen to prosecute 0 cases, enforcing those so-called major priorities?
With all due respect, Senator, just so the record is clear, a major priority of this Department of Justice is protecting the American public from violent crime, including violent gun crime. I just want to make sure that that's clear so that what my testimony is not twisted into something that it's not. And your question, sir, was?
Are there any other so-called major priorities on which you have prosecuted 0 cases?
We've made hard decisions with our resources. Priority number 1 is national security. In Minnesota, we have made major efforts on that front with Al-Shabaab. We have made major efforts on protecting our community from violent crime, including gun crime. We have made major efforts protecting the safety of people's nest eggs and financial fraud. And so we have a veritable smorgasbord of decisions that we're making, and all of our work has been consistent with the priorities of this Department of Justice.
Mr. Jones, I would note you chose not to answer my question. I just want to have one final question with the chairman's indulgence, which is that the Grassley-Cruz legislation that was introduced on the floor of the Senate that received a majority of votes on the Senate, 52 senators, including 9 Democrats, it was the most bipartisan of all of the comprehensive gun legislation introduced. It provided funding for prosecuting felons and fugitives who attempt to illegally purchase firearms, because in my judgment and in the judgment of a majority of the Senate, it is utterly unacceptable for this Justice Department to refuse to prosecute felons and fugitives who attempt to illegally purchase firearms. In your role as acting director of the ATF or as U.S. Attorney, did you support the Grassley-Cruz legislation, and do you support that legislation?
I am not familiar with the specifics of that legislation, and I'm not in a position to answer the question because I am not familiar with the legislation.
Very well. Thank you.
Senator Grassley.
A common complaint that I've heard within ATF is that U.S. attorneys' offices are unwilling to pursue straw purchasing charges. According to one account, you reportedly said of gun and drug cases, quote, "We could do that all day, but we've chosen not to because that's not the best use of our resources," end of quote. How would you expect to encourage agents in the ATF to pursue gun crime when you wouldn't think it's a high priority for yourself as a U.S. attorney?
Well, gun crime, Senator, is a high priority for me as the United States Attorney, and I think our record...
The statement I read that you said, is that statement wrong?
Without knowing the context or the specifics of the statement, it's difficult.
It was in the Minneapolis Star-Tribune.
If what I recall you may be referring to, it's an overall... it was an article that addressed what we discussed earlier as to why the drop in terms of the overall numbers in criminal prosecutions. And again, it really is driven by 3 things: our resources, our collaboration with state and locals, and what can we do that they cannot do, and focusing more on impact cases as compared to be solely driven by the numbers. I believe that was the context, because in particular in the drug and gun area in Minnesota, there's a pretty vibrant, Senator Klobuchar knows, felon in possession statute. And each of the last 3 years, county attorneys in Minnesota have prosecuted in excess of 800 individual cases, and this is subject to a reporting requirement they have annually. And so working in collaboration with them, what we have done, sometimes formalized as what we call Exile Light in Minneapolis, but generally throughout the state, is make sure that those most egregious offenders do come into federal court without impeding on the jurisdictional prerogatives of our county attorneys who do yeoman's work working with us to keep the streets safe.
You were chair of the Attorney General's Advisory Committee from 2009 to 2011. In that capacity, you were a member of the Southwest Border Strategy Group. In October '09, that group decided to distribute a draft strategy for combating Mexican cartels. The draft stated, quote, merely seizing firearms through interdiction will not stop firearms trafficking to Mexico, end of quote. The draft strategy goes on to emphasize identifying the members of armed trafficking network. The implication's clear. The strategy places a higher value on gathering intelligence about trafficking networks and on arresting straw purchasers. Now, were you there at the October 26, 2009 meeting of the Southwest Border Strategy Group? Did you approve of the strategy to de-emphasize straw purchasing cases? And do you think it's a good strategy to go for big cases instead of putting a stop to straw purchasers whenever you can?
To answer your first question, Senator, I was not there. I was brought in as the chair of the Attorney General's Advisory Committee in September, and we were ramping up with a revitalization of that and a transition. So I was not at that meeting. I was not an active participant on the Southwest Border Working Group. I was a participant on the Northern Border Working Group because that had more relevance to the District of Minnesota. With respect to your last question about opinions about the firearms case, we've made it clear from the outset that public safety will never be sacrificed for prosecutive or investigative needs. Public safety is first and foremost in what we strive to achieve in our investigations.
When you took over at ATF, you set out to clean up the shop. Rather than disciplining some of the ATF employees who were clearly responsible for Fast and Furious, you waited for an Inspector General's report, took a year. Now over 18 months, or after 18 months, after the Inspector General's report, ATF has not reported a single individual being disciplined for Fast and Furious. Nobody seems to be fired. Instead, several people were allowed to retire or terminate for other reasons. I want to ask you about a series of individuals. They're all criticized by the Inspector General for that role. For each one, I'd like you to tell me whether the ATF proposed any discipline to hold them accountable for Fast and Furious. The Fast and Furious, how about the ATF group supervisor, David Voth? What was the situation with him? How was he disciplined?
Special Agent Voth was subject to the internal disciplinary process, and there were repercussions. Again, I am very sensitive here in this context about the Privacy Act concerns, but he was subject to the disciplinary process.
The Privacy Act doesn't apply to hearings in Congress, but let's move on. How about the assistant agent in charge, George Gillette?
Former ASAC George Gillette has retired from ATF.
Assistant Special Agent Charge James Needles.
Assistant Special Agent Charge James Needles is in another capacity within ATF.
So nothing's really happened to him. Special Agent in Charge of Phoenix, Bill Newell.
There is still resolution pending that should be forthcoming.
So after all these years, nothing's happened to him. Deputy Director in Washington, Bill McMahon.
Bill McMahon is retired from ATF.
Okay, retired, not disciplined. Some of these individuals are involved in other controversies in addition to Fast and Furious. For example, I understand that the ATF's Internal Affairs Division found fault with George Gillette and Bill Newell's involvement in the investigation of a fire at ATF agent's home in 2008. In a separate matter, Gillette sold his personal firearms to a suspect 1 week after his office opened a gun trafficking case on that person. This was one of multiple firearms transactions Gillette that are currently under investigation by the Inspector General. Another is a gun that Gillette bought that was recovered at a murder scene of a Mexican beauty queen alongside a gun from Fast and Furious. However, instead of Gillette being disciplined when you took control of ATF in the summer of 2011, he was allowed to wait it out and retire in 2012. Why did you allow Gillette to retire rather than hold him accountable?
Senator, with all due respect, there are processes in place, and these processes do take time. You mentioned the Privacy Act, the specifics of each of these cases. I would like to just make sure that you understand, that the American public understands, that we did not stand idly by and not take corrective action, including disciplinary action, according to the rules of the road and the processes that are in play that sometimes are painfully slow. But all of the individuals you mentioned did get their due process. Many of them were ably represented by counsel.
Well, can you even tell us what discipline was proposed against Newell as a result of the October 2012 report?
That is a matter that is quickly coming to resolution, and as soon as we can disclose it to you, we will.
ATF Deputy Director William McMahon was the official in Washington, D.C., primarily responsible for supervising Gillette and Newell. The Inspector General criticized him for his failure to.
We very much appreciate the information enhancing our level of knowledge about things that were already in play internally, but the end result was Mr. McMahon was terminated from ATF.
You have stated that on November the 3rd, 2011, you issued a memorandum saying that the ATF must take all reasonable steps to prevent criminal misuse of firearms. Will you provide a copy of that memorandum to the committee?
I believe that is a updated ATF order that we will provide.
Okay. What guidance have you issued to ATF on the issue of questioning suspected straw purchasers?
I'm not quite sure I understand the question, Senator.
Well, you've issued some guidance to the ATF on the issue of questioning suspected straw purchasers. What does that guidance say? In other words, you've got people out there questioning straw purchasers. What guidance have you given to them for this questioning?
Well, as I said here, Senator, other than the fact that we have special agents who are sometimes involved in the investigation of firearms trafficking that would lead them to question as any other potential suspect, I'm not aware of any special guidance that would carve out straw purchasers.
Well, what about guidance issued to ATF about cooperating federal firearm licensees and their role that they should play in investigations?
With respect to that particular issue, I do know that after I arrived at ATF, one of the issues that we addressed were weaknesses and lack of clarity in our confidential informant order internally. We did a review of that, as we did with the undercover order, and we revised appropriately based in part on things that did not proceed as they should in the District of Arizona. So we have greater clarity on the use of FFLs as confidential informants currently in place.
Despite the congressional prohibition against keeping a national gun registry, I know that ATF keeps a suspect gun database. Is there any legal standard that ATF agents are required to meet before adding information on a purchaser to a suspected gun database?
Well, if the senator is talking about our e-trace or our tracing capability, then those are crime guns that are entered in with make, model, and serial number. As you and many others are well aware, it is the Firearms Owner Protection Act of 1986 precludes anything a national gun registry, and it would be illegal to do that.
I've also heard allegations from several states of ATF agents going to federal firearm licensees and taking pictures of every Form 4473 in the store. Have you heard of this practice, and is this the kind of activity by ATF agents acceptable to you?
As I sit here, I am not familiar with the practice. I do know that our industry operations investigators, all 700 plus of them, with the range of responsibilities that they have with literally tens of thousands of FFLs, work very hard to do the appropriate inspections of FFLs, and that's difficult work.
My staff says to me that, by note here, that we're not talking about tracing. We're referring to suspect gun database, which was used extensively in Fast and Furious.
As I sit here, I'll have to...
Well, then I'll let you answer that question in writing.
Yes.
Thank you. On October the 12th, 2012, the House Committee on Oversight and Government Reform subpoenaed, quote, all agendas, meeting notes, meeting minutes, and follow-up reports for the Attorney General's Advisory Committee that refer or relate to Operation Fast and Furious, end of quote, during the time that you were chair. The Justice Department has never produced any such documents or certified that none exist. Do any such minutes or notes exist, and if so, why haven't they been turned over pursuant to subpoena?
Well, I don't have any knowledge beyond the fact that relevant documents have been collected internally at the department, and that matter is probably a part of litigation. That if anyone ever wants to ask Mr. Dellery questions, I'm sure he can provide greater clarity about ongoing litigation involving production of documents pursuant to subpoenas.
Well, let's just suppose you said you didn't know, and that's maybe legitimate. Let me ask you if you would respond to that question in writing.
To the extent I have those documents still, and then we'll respond in writing, Senator. Yes,
or
we will.
If they're available any place that you can put your hands on them. On April the 12th, 2013, I sent you personally a letter requesting that you provide any personal notes from the advisory committee that you may have taken regarding Fast and Furious. You have not provided any such notes or certified to me that you don't have any such notes, and so why have you not responded?
Well, Senator, right out of the blocks, I don't have, as I sit here, any recollection of a letter that's got that specific request. But as I said before, all of the documentation related to my tenure at the Attorney General's Advisory Committee is at the department, and I'm sure that review and production processes have taken place.
U.S. Attorney for the District of Arizona, Dennis Burke, was also on the Attorney General's Advisory Committee during the time you were chair. Have you ever discussed Operation Fast and Furious, whether by name or otherwise, with Burke? If so, when?
Senator, I did serve with Dennis Burke when I was chair of the AGAC, and in fact, Dennis Burke was chair of the subcommittee for the Southwest border, and our conversations were always at a higher level than the specific cases that were ongoing in the District of Arizona, so I have no recollection of discussing that case specifically with Dennis during my time as chair.
Burke testified that as a result of Fast and Furious, he raised the issue of Title III wiretap approval with the advisory committee. What do you recall about those discussions?
My general recollection was the pace with which and the volume of Title III requests that the Office of Enforcement Operations, in an effort through the U.S. Attorney community to try and enhance their capability to review Title III applications generally.
We recently learned from a follow-up Inspector General's report that Deputy Attorney General Cole reprimanded Dennis Burke for his role in leaking documents related to Fast and Furious to the press. The leak was part of an attempt to undermine the credibility of the primary whistleblower, ATF Special Agent John Dodson, which is a perfect example of what I tell you about so often, or not just your agency, but every agency in town. Whistleblower is about as welcome as a skunk at a picnic. What was your opinion of Burke's unauthorized release of information about ATF's agents' participation in an undercover operation?
I think the circumstance with Dennis Burke is unfortunate. I know what the rules of the road are with respect to appropriate communications in the U.S. Attorney Manual, and I don't have an opinion one way or the other about the facts and circumstances because, quite frankly, I know as much as you know on the public record about interactions between former U.S. Attorney Burke and the Deputy Attorney General.
So then is that your answer to my next question? When and how did you learn that Burke was responsible for the leak?
That is the answer. I know as much as you know when you knew it, when it became part of the public record.
Can you tell me, did you ever discuss the document that Dennis Burke leaked with Mr. Burke? If so, please describe those discussions.
I don't have any recollection of having those kind of discussions with Mr. Burke.
Madam Chairman, I have some documents that I want to put in the record, if I can.
All right.
The first one deals with a letter dated June the 10th, 2013 from Carolyn Lerner at the Office of Special Counsel explaining that the investigation of Mr. Jones is in mediation but is not a closed matter.
It's in the record.
The second one is a letter from Oswald that I've referred to, the former FBI special agent in charge that I've referred to several times that should be made a matter of the record. And then I have whistleblower letter from the White House. The letter's addressed to Senator McCaskill and CC'd to me, describing the administration's views of whistleblowing protection. I'd like to quote, "We wish to encourage such individuals to expose waste, fraud, and other improper behavior. The administration has been steadfast in its commitment to that very principle and to ensuring that individuals who make lawful disclosures receive legal protections they deserve. This administration," and this is highlighted, "this administration has also repeatedly made clear that it will not tolerate retaliation against lawful whistleblowers." Editorial comment on that. I believe every president, at least since Reagan, I've talked to every president about protecting whistleblowers. And you know what one president said when I suggested that you ought to have a rose garden ceremony honoring some whistleblowers, and you'd send from the top of the administration down to the lowest level of public employment a clear picture that being a whistleblower is a patriotic thing to do if you happen to be right what you're whistleblowing about. And you know, one president told me, he said, well, if we did that, we'd have 3,000 whistleblowers coming out of the woodwork. Now, isn't that a nice thing for a president to tell me? And it wasn't this president that told me that. And so, I believe what the president said here, but it isn't getting down to the lowest levels. And I hope if you are confirmed, Mr. Jones, that you will do what the president has said his administration wants to do, and do that. The only thing I would say in conclusion, Mr. Jones, if you had agreed to a staff interview, these things that we're discussing here could have been discussed in a private forum, and I'd like to ask you why you didn't give the staff interview we asked.
Senator, I look forward, if I'm confirmed, to having regular communications in an oversight capacity with you and your staff and members of this august body.
That doesn't really answer my question, why you didn't respond to our request that you give us staff interview.
I did have an interview with respect to a particular matter, but
What about the other matters that we asked you to have a staff interview with it? I mean, is it embarrassing for you to tell us why you wouldn't come?
I'm a member of the Department of Justice, and
They told you not to?
I can't. I did. You know, under some circumstances, Senator, I do not have the freedom of action as I did as an individual citizen.
Secondly, the support from law enforcement I've mentioned that's in the room, people who have worked with Jones over a period of time, I think that's important. Some of the issues that were raised, I think it was Senator Coons who asked some questions about the St. Paul case. I think that's important to have on the record, and we have those on the record. Fast and Furious, obviously, Senator Grassley and Senator Cruz, Senator Flake all asked about this, and I would say that if you were in the private sector and something went greatly wrong, one of the things you looked at was, are the people still in place that were in charge when this happened? And as Mr. Jones has pointed out, I think he changed nearly 2/3 of the people in charge at the agency when he came in after Fast and Furious, that there have been disciplinary proceedings that are underway and have been concluded. I understand why he can't attach a discipline to every single name of a person, and I know he'll work with the senators who were concerned about that, but I do think it's really important to note that he was brought in after Fast and Furious, after clear mistakes had been made in the agency, to make some changes. I don't think that we should forget the good work that's been done by ATF in just the last few months with Sandy Hook, with the investigation after Boston and how quickly those terrorists were apprehended, and then also what happened in West Texas, which was a horrible tragedy, a horrible explosion, and ATF was right there on the front line figuring out what went wrong. And as I also pointed out, day in and day out, there are cases that you don't read about in the news where solutions are found, where investigations are conducted. So that is the last part, of course, would be the whistleblower case in Minnesota. I know that person. I have respect for him. I know there can be disagreements. I'm glad this is going into mediation. I think that's very important. But when you look at this whole everything together, I think anyone in law enforcement would be able to find a series of problems within agencies. And I think what you have to look at is, what has Mr. Jones done since he took over ATF? Is that worthy of merit? Is it worthy for other future nominees decades from now to be able to show that if someone comes in and is willing to take that responsibility, instead of just keeping their job, keeping happy with their families, staying in the state they're in, and they're willing to take on a really hard job and do above average, as we like to say in Minnesota, in terms of trying to clean things up? Is that to be rewarded, or is that to be criticized? And so I just end with a quote that I gave my daughter in the car. It's kind of one of those cliche quotes, but I thought it was so fitting when I was trying to get her to do something the other day. And so I took out that old Roosevelt quote where he said, "It is not the critic who counts, not the man who points out how the strong man stumbles or where the doer of deeds could have done them better. The credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs, who comes short again and again, because there is no effort without error and shortcoming, but who does actually strive to do the deeds, who knows the great enthusiasms, the great devotions, who spends himself in a worthy cause, who at the best knows in the end of the triumph of high achievement, and who, at the worst, if he fails, at least fails while daring greatly, so that his place shall never be with those cold and timid souls who neither know victory or defeat." Now, when I tried that quote on my daughter, she said, "That's just about men. They only use the word man." I think I've tried to get beyond that to say that Mr. Jones was willing to take on a very tough assignment. Again, I think we owe these agents to have a permanent director I think we should get him confirmed. And I hope, despite all of the work of Senator Grassley at bringing out these important questions, which we must do when we have a nominee before us, that we are able to move forward and get through this and do this in a timely manner. I also thank you, Mr. Dellary, for your fine credentials and the work you've already done with the Justice Department and your most amazing family seated behind you, who continue, I can tell. If you can manage the civil division of the Justice Department as you clearly manage your kids, you're going to do a really good job. That was positive to the boys. That was a very good thing. I want to thank both the nominees, their families, Anthony out there, everyone who's been willing to sit through this hearing, as well as the senators who are willing to attend. I hope we can move forward with this nomination. I also want to thank Carolyn Holland of my staff, who headed up the work on this, as well as Senator Leahy's and Senator Grassley's staff. Thank you. As noted, the hearing record will be open for 2 weeks unless the chairman decides to change that, and we will move forward, I hope, to a vote on this nominee. Thank you, and the hearing, and the other nominee. The hearing is adjourned.